So welcome to Jumbo IS and welcome to our lecture series called Prelims Powerplay. Now within this lecture series of Prelims Powerplay, we have started with Polity. And as you know already, if you have watched yesterday's lecture, that we have divided the entire section of Polity into 6 topics. And within those 6 topics, we will try to cover the entire 1 year's current affairs from Polity, from the subject of Polity. Okay. Now those 6 subjects or those 6 topics within the broader subject of Polity, well, I have discussed about that in the previous video. So go check that out if you do not know about that already. Okay. Today we are going to start with Prelims Powerplay Polity lecture number 1. Okay. And lecture number 1 deals with the topic of executive. Okay. Now within the topic of executive, what subtopics we shall cover? Let's take a look at that. Okay. So let's start this lecture very quickly because time is of the essence. Okay. Okay then. So let's start with executive. Okay. Now within executive, these are the 5 topics that we shall cover. Supreme Court ruling on Tamil Nadu governor. This was a very landmark ruling. Okay. It basically expanded on the role of governor. Okay. Then president's rule in Manipur. Then prior sanction to prosecute public servants. Okay. What does this prior sanction means? What permission does they mean by prior sanction? Then we'll talk about Law Commission because last year 23rd Law Commission was constituted. So what is this Law Commission? And then we'll talk about governor's immunity from criminal action as mentioned in Article 361 of the Constitution. What do we mean? What is the scope of this governor's immunity? Okay, so let's start discussing all these 5 topics one by one. Let's start with SC ruling on Tamil Nadu governor. Okay. Now, let me explain to you the controversy first and then we'll talk about this issue in its totality. The controversy was, look, governor is appointed by central government and the power to remove a governor also lies with the central government. Now, that is okay. But sometimes opposing parties rule central government and state government. Sometimes the party that rules the central government and the party that rules the state government are opposite to each other as far as their politics is concerned. Now, governor, because he is appointed by the central government and he is removed by the central government, well, in a way, sometimes acts as an agent of central government. Okay? And most of the times, the governor who acts as the agent of central government is involved in this conflict with the state government because the ruling party of the state government is in conflict with the ruling party of the central government. That's precisely what happened in Tamil Nadu. It has happened in past also in many other states. But recently it happened in Tamil Nadu. What happened was, as far as our constitution is concerned, well, governor is the constitutional head of the state. All bills passed by the state legislature should be assented to by the governor. Okay. So all bills passed by the state legislature will become law when the governor gives his signature, gives his assent. One more thing. Governor acts on the aid and advice of Council of Ministers of the state government. But there are certain matters in which government can act on his own without the advice of Council of Ministers. Okay. And it is this area, this act on his own, which is the point of controversy. Okay. Because sometimes this act on his own, at his own discretion, is interpreted by governor differently and interpreted by the state government differently, and that leads to conflict. Sometimes governor completely acts as an agent of central government and there is a diff. Okay. Now this was the case in Tamil Nadu and the case was filed in Supreme Court and Supreme Court gave a judgment on the role of Tamil Nadu governor. Okay. Which clarified a lot of things so that these conflict-like situations don't repeat themselves in the future. Okay. So now let's talk about this issue. Okay. So Supreme Court ruling on Tamil Nadu governor. First of all, let's talk about the constitutional role of governor. Okay. Now, look, Article 200 is pretty clear. Article 200 of the Constitution says that the governor can take following actions when a bill is passed by the state legislature. Okay. So as soon as a bill is passed by the state legislature, the governor can grant his assent. Once he grants his assent, then that bill becomes a law. Can withhold his assent. okay, can refuse to give his signature, then it won't become a law. Can send it back for reconsideration. Okay, send it back for reconsideration. Let's suppose state legislature passed a law, passed a bill, governor says that please reconsider it. Okay, but governor can do that only in the case of ordinary bills. If that bill passed by state legislature is a money bill, governor cannot send it back for reconsideration. Okay, or governor can reserve that bill for president's consideration, president of India. So if a bill is passed by state legislature, governor might think that this will require the consideration of the president, so I'll send it to the president. Once it comes back from the president, then only I'll sign it. Make sense? Now, these are the actions that are mentioned in Article 200 of the Constitution that the governor can take. Okay, but one thing. If the governor has sent a bill back for reconsideration and the state legislatures repass it and send it back to the governor, then the governor has to give his signature. Then the governor cannot say, I won't give the signatures. Make sense? So if it is sent back to the governor, then the governor has to give his signatures. Okay. Now, let me familiarize you with certain terms. Okay. If a governor withholds assent, this power is known as absolute veto. Absolute veto over the bill. If the governor sends it back for reconsideration, then this power is known as suspensive veto. Which means that the governor can suspend this bill for some time. If it is repassed by the state legislature, then he has to give his signature. Okay. The governor cannot withhold assent if the bill is repassed after reconsideration. Okay. So, governor has two powers, absolute veto, suspensive veto. Clear? Now, what happened in Tamil Nadu's case was that, well, there were 10 bills that were passed by Tamil Nadu State Assembly. The governor sent them back for reconsideration. Tamil Nadu Assembly repassed them and sent it back to the governor. Now it was mandatory for the governor to give his assent. But what did the governor do? Governor reserved those repassed 10 bills for president's consideration. Basically, governor was using a delaying tactic. And how can the governor use a delaying tactic? Because Article 200 of the Constitution is silent when it comes to the timeline. Time in which the governor has to give his assent. The Constitution is silent. In how much time the governor can withhold his assent, grant his assent, send it back for reconsideration, reserve it for the president. There is no timeline mentioned. And sometimes governors, if they are from opposing political parties, they take advantage of that. Because there is no timeline mentioned, well, governor can keep it and say, yes, I'm giving my assent, but does not. Right? This is known as pocket veto. So, governor keeps the bill in his pocket and says, I'll consider it. I'll see what I can do about it. Okay. So, because no timeline within which the governor has to give his assent is mentioned in the Constitution, hence, in effect, the governor has pocket veto. And this pocket veto was controversial in the recent case. And that is why a case was sent in the Supreme Court. And Supreme Court gave a judgment so that this pocket veto is not misused in future. Now, what was that judgment? Okay, so Supreme Court's judgment. Withholding or referring the bill to the president was deemed unconstitutional after reenactment by the state legislature. Okay, so if state legislature repasses that bill and sends it to the governor, then the governor has no absolute veto, no pocket veto. The governor cannot send it to the president. That would be deemed unconstitutional. That's what the Supreme Court has said. Plus, there is this article in our Constitution called Article 142. This article basically gives our Honorable Supreme Court a sort of superpower. If Supreme Court feels that complete justice is not being done in a particular case, then Supreme Court, using this Article 142, can assume the role of any authority in India for doing complete justice. Though Supreme Court has a limited role, but Supreme Court can take the role or assume the role of a governor, state government, anyone in the country to do complete justice as per Article 142. Okay. Now, in Tamil Nadu's case, what happened was that the governor had reserved these 10 re-enacted bills by the Tamil Nadu Assembly for the consideration of the president. Supreme Court, using Article 142, deemed those 10 bills to be passed assented by the governor. Though the governor did not give his signatures, but Supreme Court, using Article 142, assumed the role of the governor and gave the assent, deemed those bills to be passed, because Supreme Court said that reserving those bills after reenactment for president is unconstitutional. So this Article 142 is also very important. Plus, Supreme Court also said one more thing. Article 163 is very clear, okay? The governor must act on aid and advice of Council of Ministers. Okay, the governor shall always act on the aid and advice of the Council of Ministers, but Article 163 says, except in cases where his discretion is allowed, where governor can act on his own. Now, Supreme Court has made it clear that the governor can act on his own only in case of second proviso of Article 200. Second proviso of Article 200 says that if a state assembly passes a bill that reduces the powers of a high court, then the governor should reserve that bill for the consideration of the president. In that case, the governor is not bound by the advice of Council of Ministers. Okay, it is only in this case that governor's discretion is allowed. Plus, the Supreme Court also gave a timeline where the constitution was silent. Supreme Court gave a timeline: 1 month to assent, 3 months if governor withholds assent against advice, and all that. Okay, so this timeline was also given by the Honorable Supreme Court. Now, as far as the role of governor is concerned, it has always been controversial. Always been controversial. In fact, in the past also, Supreme Court has given so many judgments. So let's take a look at those past judgments with respect to the role of Supreme Court, okay? Because a question might be asked. So, these were the judgments. Shamsher Singh versus State of Punjab. In that, the Supreme Court stated that governor is bound by the aid and advice of the Council of Ministers as a rule and can only exercise his discretion as an exception. Okay. So, in Shamsher Singh versus State of Punjab, Supreme Court reiterated that governor should be bound by the aid and advice of Council of Ministers and his discretion should be used exceptionally. Then, in 2006, Rameshwar Prasad versus Union of India, the court held that the individual opinion of the governor cannot be the ground for imposing president rule. The only, because governors used to give their opinion that president rule should be applied in a particular state and the president used to apply. So the Supreme Court said in Rameshwar Prasad case that the only opinion of the governor is not the ground. Okay, you should take a broad-based opinion. Basically, that was the case. Just remember the name of the case and its landmark ruling. Then Nabam Rabia versus and Bamam Felix versus Deputy Speaker Arunachal Pradesh. Well, the governor has the power to summon a house. Okay. Now, that is not an exclusive power of the government. That's what, well, the Supreme Court said. Okay. Now, there are two issues that are still contentious with respect to the role of the governor. Okay. And they haven't been resolved. These two issues are, well, the power to grant sanction for prosecution against state government officials. Well, we'll discuss about this. Before prosecuting, criminal prosecution, before you launch a criminal prosecution against public servants, you require permission of the government. Okay? And governor gives that permission. So this is a contentious issue. And sometimes when an election takes place in the state, well, no party gets a majority. Now, in that regard, the role of the governor is contentious. Okay, which party will he invite to form the government and prove the floor test? This is still contentious, though there have been many judgments with respect to that, but it is still contentious. Okay, so yeah, these are the two issues which are still contentious with respect to the role of the governor. That's all as far as topic number 1 is concerned. Now, let's move on to topic number 2, which is President's rule in Manipur. Now, as you all know that Manipur has been facing a very bad situation since 2023, right? And in that regard, the Chief Minister's role has been criticized. Many people within BJP were also demanding Chief Minister Biren Singh's resignation. Now, recently he resigned, okay? And the central government had to impose President's rule there. Now, imposition of President's rule in state governments has been a controversial issue since the formation of Indian Republic. Okay, it has been a controversial issue, very controversial, and there have been many Supreme Court judgments to reduce that controversy. Now, though imposition of president's rule in Manipur is not that controversial, but in the past, president's rule have been controversial. Now, what president's rule essentially means is that if governor of a state feels that the state machinery has broken down, state government cannot run in accordance with the constitution, then he will give a report to the president and the president will impose president's rule there. The provision of president's rule is mentioned in Article 356 of the Constitution. So let's talk about the entire constitutional provisions with respect to the president's rule, okay, and what judgments have been there in the Supreme Court so that this provision is not misused. Okay, so let's talk about Article 356, which explains the issue of president's rule in its entirety. Okay, what are the constitutional provisions and the Supreme Court judgments to prevent misuse of imposition of president's rule. Okay, so let's talk about that. Let's quickly jump to that. So yeah, president's rule in Manipur. Okay, so what does the Article 356 says? As you should know this, Article 356 deals with president's rule. Okay, the president through proclamation, he has to announce, enforce president's rule in a state on receiving a report from the governor. Now the constitution clearly mentions that the governor has to file a report with the president, and in that report governor has to prove that the constitutional machinery has broken down. The state cannot run in accordance with the constitution, provisions of the constitution. On being satisfied with that report, the president through proclamation enforce president's rule. Now, as soon as president's rule is enforced, okay, as soon as president's rule is imposed, it effectively transfers the functions of state government with central government, and state legislature with parliament. Now, laws with respect to that state shall be made by parliament, and all the functioning of the state government officials comes under center. The only exception is that the High Court remains. The powers of High Court remain. Okay. Now, what is the procedure mentioned in Article 356? You should be familiar with that. The proclamation is valid for 2 months. So, as soon as the proclamation is made by the president, it is valid for 2 months. It will expire after 2 months unless both Lok Sabha and Rajya Sabha through a resolution approve that proclamation. Once Lok Sabha and Rajya Sabha approve that proclamation, then it shall continue till 6 months. Okay. After 6 months, Lok Sabha and Rajya Sabha should again pass a resolution to extend it by further 6 months. Okay. This process of extension every 6 months can go on till 3 years. But the catch is, if Lok Sabha and Rajya Sabha have to extend it beyond 1 year, okay, after 1 year, then they can extend it only and only if national emergency is there. Okay, so this process of giving extension can go on till 1 year. If you want to take it till 3 years, then just after 1 year, Lok Sabha and Rajya Sabha can only pass a resolution if national emergency is imposed. Under Article 352, national emergency is there, then they can do it. Or the Election Commission of India basically proves that it is difficult to conduct elections in that state. So if these two conditions are satisfied, then beyond 1 year, Lok Sabha and Rajya Sabha can extend it till 3 years. That's the thing. Okay. Now, some important facts with respect to president's rule. You should know about this because, well, questions might be asked. So since 1950, when the constitution first came into force, president's rule has been imposed a total of 134 times across 29 states and UTs. So all states and UTs have had president's rule at least once in their past. Okay, 134 times. The states that have had maximum number of times president's rule have been imposed there, well, it is Uttar Pradesh and Manipur. So in Manipur and Uttar Pradesh, president's rule has been imposed 10 times each. But these are not the two states where the state machinery was under central government for longest period of time. Yes, the number of times president's rule was imposed was the highest in these two states. But if we talk about time, Well, Manipur and Uttar Pradesh are not they haven't suffered the longest time under, not suffered, but stayed the longest time under central rule. Okay, it is actually Jammu and Kashmir, which stayed under central control for 12 years, then Punjab for 10 years, and both Jammu and Kashmir and Punjab stayed under president's rule because of security situation. There was a period of insurgency in Punjab and Jammu Kashmir, as we all know. And Pondicherry has stayed under president's rules for 7 years. Though the reason for Pondicherry staying under president's rule for 7 years was not security situation, it was basically no party received a majority and was able to form a government. Nonetheless, this is the situation. Now, when it comes to misuse of president's rule, well, before 1990s, president's rule was misused by the central government rampantly. Whichever party was in power in the center, well, they used to dismiss state governments willy-nilly through Article 356. Then in 1990s, a landmark judgment of the Supreme Court came, which is called S.R. Bommai case. Okay, and within this S.R. Bommai case, basically, Supreme Court gave certain conditions which have to be fulfilled if president's rule is applied. Okay, and because of this Supreme Court's judgment, okay, 1994 S.R. Bommai case, well, after that, after 1994, president's rule became a little rare. Before that, it was the norm. It was quite rampant. Clear? Make sense? Okay. So remember the name of this judgment, S.R. Bommai case. Okay. Now let's quickly jump to third topic, which is prior sanction for prosecuting public servants. Now look, the thing is that in our country, public servants are protected from criminal prosecutions to a certain extent. Whenever a case is filed against a public servant, well, to start criminal proceedings against a public servant, you have to take the permission of the government. Only after getting the permission of the government, well, you can start criminal proceedings against a public servant. Okay, that is mentioned in our law. Okay, the reason for bringing this provision in our law was that public servants should do their duty fearlessly. Okay, they shouldn't be scared of useless false accusations or false criminal proceedings. Sometimes, well, another government comes to power who doesn't like that particular public servant, so they can fabricate false cases against them. Okay, that can happen. So to prevent public servants from being harassed due to false cases and to basically allow them to do their duty fearlessly, okay, without the fear of criminal prosecution, this provision was added. Now recently, Supreme Court gave a landmark judgment with respect to this also. So what was that landmark judgment? Before understanding that, you need to understand what this provision is all about. Okay, so let's talk about this. So prior sanction on public servants. Okay, so as per section 197 of CRPC, Criminal Procedure Code, which was enacted in 1973, Criminal Procedure Code has now been replaced by Bharatiya Nagarik Suraksha Sanhita. We all know about this, okay? So as per section 218 of BNSS or 197 of CRPC, this bars courts from taking cognizance of offences alleged to have been committed by a judge or a magistrate or a public servant. Okay, courts cannot start criminal proceedings against these people unless previous sanction or permission of the government required is taken. Okay, but this protection is provided to a public servant, judge or a magistrate only in cases of actions that were well done by him in discharge of his official duty. If he has taken a personal action which was criminal, then no permission is required. But for filing a criminal case against this public servant, if he was acting or perpetrating to act in the discharge of his official duty, then you require previous sanction. Okay, so this distinction is important. Plus, section 197 and section 218 won't apply if the case against that public servant is with respect to crimes against women like rape, sexual harassment, stalking, voyeurism, and won't apply if the cases are related to human trafficking. In these two cases, well, no permission is required of the government. In everything else, permission is required. Now, the recent landmark judgment given by Supreme Court was with respect to Prevention of Money Laundering Act. Okay, there were some allegations with respect to money laundering against some public servants. Now, officials believe that Section 197 does not apply to PMLA. Okay, if you are accused of money laundering, we don't require a permission. Clear? But Supreme Court made it clear that Section 197 and Section 218 also applies to PMLA. So, if you are prosecuting or starting a criminal proceeding with respect to money laundering against a public servant, then 2 previous sanction is required. Exception is only against cases of crimes against women and human trafficking. Okay, this is something that you need to know. Remember Section 197 or Section 218. Okay, remember this part. Clear? That would be all as far as this topic is concerned. And now let's quickly jump to Law Commission of India. Now, Law Commission of India is established almost every 3 years or 4 years, okay, and it is established by Union Ministry of Law and Justice. Again, the purpose of Law Commission is to give advice to the government with respect to laws in the country. Which laws should be changed, which laws should be amended, which laws should be applied, which laws are obsolete, so they should be done away with. All these things require careful consideration. And for that purpose, Law Commission is appointed. Okay. Now remember, it is not a constitutional duty to appoint Law Commission. Law Commission is not a constitutional office. Law Commission is not a statutory office as well, which means that it is nowhere mentioned in the law, in any law, including constitution, that you have to establish Law Commission. It is just established by the government for its own purpose. No legal requirement is there, no constitutional requirement is there. So it is a non-statutory office. Just remember this part. Okay. Other information with respect to Law Commission, let's talk about it. Okay. So yeah, Law Commission. Now the reason why Law Commission was in the news was because, well, from 2nd September onwards, 2nd September 2024 onwards, well, 23rd Law Commission was established. The term for 22nd Law Commission ended on 31st August. And you had to establish a new Law Commission. So on 2nd September, you established that new Law Commission. Okay. That was the thing. That is why it was in the news. Now let's talk about Law Commission. Okay. So it is a non-statutory commission. It is formed by Union Ministry of Law and Justice through a gazette notification. Functions. What are the functions of Law Commission? Review functioning of laws. How the laws made by Parliament are functioning. Are they being implemented properly? Suggest repealing of obsolete legislation. So if there is a legislation that is obsolete, well, repeal it. Make recommendations on matters referred to it by the central government. So any matter referred to it, any legal matter referred to it by the central government, well, they have to review it also. Now, usually it is chaired by a retired judge of the Supreme Court or a High Court, and some legal scholars are its members. Okay. Serving judges can also be appointed to the commission. Clear? The current 23rd Law Commission has basically 1 chairman and 4 members. Okay, but it can change. It completely depends upon Union Ministry of Law and Justice. Now, what has been the history of Law Commission? Let's talk about this. Okay, so 22 Law Commissions have been established before 31st August 2024, appointed since independence, and they have submitted 289 reports to the government. The government is under, remember this part, the government is under no obligation to accept these reports because there is no legal requirement to establish this commission, no constitutional requirements. Therefore, their reports are just advisory in nature. The government can choose to accept them or reject them. Though the government does take those reports seriously. In fact, in the past, well, after a Law Commission report, government enacted CRPC in 1973. After a report by Law Commission, government enacted Right to Education Act. Okay. After a report by the 20th Law Commission, government scrapped 1500 laws that were obsolete. So Law Commission reports are important. Okay. That's all. That's the information that you need from this topic as well. And now let's quickly jump to last topic, that is governor's immunity. Okay. Now listen to me carefully. The thing is that Article 361 of our Constitution provides immunity against criminal and civil cases to the Governor of India and the President of India. Okay. Now Article 361 has three clauses. Clause number 1 says that any action taken by the governor in his official capacity, if it turns out to be wrong and there is a criminal case, then the case won't be filed against the governor. The thing is that any action taken by governor in his official capacity, he shall be protected from any case against him on that regard. Why? Well, we all know that governor acts on the aid and advice of Council of Ministers. Okay, all actions in the government are taken in the name of governor, but governor doesn't take those actions basically based on his rationality. He is bound by the aid and advice of Council of Ministers. So if Council of Ministers have given him a particular advice and he signs on it, it shouldn't be governor's fault. It should be the fault of Council of Ministers or the officers responsible to them, right? So Article 361 provides immunity to the governor as far as his official actions are concerned. This is mentioned in Article 361 Clause 1. But Clause 2 and Clause 3 also protect the governor against criminal cases on those actions which he took in his personal capacity, not official, personal capacity. So all actions taken by the governor in his personal capacity are also protected from criminal prosecution as long as the governor stays in office. Once he's out of office, then you can launch a case. Then he becomes a normal person, normal citizen of India. But till the time he's the governor, well, he's protected from criminal prosecutions on personal acts as well. Clear? So let's talk about this. Okay. So governor's immunity as protected by Article 361. So what does the Article 361 says? So Article 361 Clause 1 protects governor's official actions. Okay. Article 361 Clause 2, well, is this: no criminal proceedings whatsoever shall be instituted or continued can take place while the president or the governor holds office. Okay, so as long as a person is the president or the governor, no criminal proceedings whatsoever shall be launched in any court. Okay, Article 361 Clause 3 is this: no process for the arrest or imprisonment can take place while the president or the governor holds office. Let's suppose a case was launched against a person and it was proven that he was guilty and then he was made the governor. Now arrest warrants are against him, but he's the governor now. So no arrest can be taken or no arrest can be made as long as he's in the office. Once he's out of the office, then you can make that arrest. He shall be protected for the time he's in office or she is in office. All right. So this clause 3 protects from arrest. Clause 2 protects from criminal proceedings even in personal cases also. Now the reason why I included this in our lecture, Article 361, because there was this controversy last year because West Bengal's governor was basically, some allegations were made with respect to sexual harassment by an employee in the governor's office against him. So West Bengal governor was facing sexual harassment charges or allegations against him. Okay. Now the question with the Supreme Court was that yes, Article 361 Clause 2 protects him from any criminal proceedings. But when do criminal proceedings start? Do criminal proceedings start only when the court starts talking about it? If that is the case, then FIR can be registered against him and case in the court will start after that governor is out of office. But if criminal proceedings start from FIR itself, then even an FIR cannot be lodged. Okay, so Supreme Court is basically making a decision when do criminal proceedings start, whether they start with FIR or whether they start when the charge sheet is filed in the court. When does it start? Okay, whenever it starts, that process will be halted because the West Bengal governor is in office. Make sense? Clear? All right. And with that, we conclude today's session. Thank you so much for watching, everyone. And I'm sure it has added value to your preparation, but well, I'm sure it has added value. So please be consistent and regular with this lecture series. It is really important. Okay. By the way, by the evening today, you'll get the notes and practice MCQs from this lecture. Please do not forget to check them out. It will hardly take 25 minutes to revise the notes and practice MCQs. So please do not forget them. Okay. So yeah. Alright then, on that note, I'll be signing off with the promise of seeing you again with lecture number 2 of Prelims Powerplay Polity. Thank you everyone.